Hello and welcome to this talk on bringing a claim for judicial review. My name is Declan O'Dempsey, I'm a barrister at Cloisters Chambers, and in this talk I'm going to be dealing with the applications you might want to make once you've started your claim. These are known as interim applications. In a later talk I'll deal with applications you might want to make before your claim has started. Interim applications are governed by the Civil Procedure Rules, Rule 23. They can be made at any time after the commencement of a claim, and the way you do is to file your application with the Administrative Court Office on an application notice form. Now this is going to be either form N244 or PF244. You also have to accompany the application with a payment of the relevant fee, so that has to be actually with the application. You need to provide evidence stating why the direction or order that you're seeking is required, and you need to provide a draft order, so that's your version of the order that you want the court to make. And we'll deal with writing an order later on in this series. In relation to the other parties to your claim for judicial review, if possible you should send a copy of the application, evidence and the accompanying draft order to them, giving them notice that the application is being made, so telling them that in a few days' time you will be making the application, i.e. putting them on notice of your application. If you make the application without giving notice to the other parties, your supporting evidence must explain why you made the application without giving notice. You should also, in your notice, request the type of hearing that you want. What I mean by that is that you can either just ask for the judge to make a decision by considering the papers, or you can request that the application is considered at an oral hearing, so where you appear in front of the judge or master and make submissions. The Administrative Court Office, when it gets your application, sends the paper either to a judge or to the master or to the Administrative Court Office lawyer for them to consider. A judicial order can be made by any of those on the papers alone if it's thought that a hearing wouldn't be appropriate. Otherwise, a hearing can be listed, which means you're notified of when it's going to be heard, and then the oral application can be heard. It is important to note that these sorts of hearings are listed at short notice. So in other words, you don't get very much notification of the date at which you've got to turn up to the court. So, as in everything, it's a good strategy to prepare for your interim application hearing early. You need to give an estimate of the amount of time you think that the hearing will take. In fact, all of the parties should indicate the likely length of time that the application hearing would take if the court decides to have an oral hearing. So even if you're asking for a paper consideration, so you just want the judge to look at the papers and make a decision, nonetheless you should indicate how long you think the application will take if there was going to be an oral hearing. Now, I want to say something about the question of the length of the hearing. Whenever you're considering this, it should include the time for giving judgment. So what you should try to do is to factor in a proportionate amount of time and indicate how much time you put in for this element. The court may well have a better idea than you of how long the judge is likely to take to give judgment, but will be helped by your idea of how long the judge is likely to take to give judgment. This can be quite difficult if you're representing yourself, and very often the lawyers in the case will have a slightly better idea of how long a judgment is likely to take. One of the interim applications you might want to make is a request to suspend or to stay the claim. So in other words, to pause the claim, and sometimes this is sensible to do. If you want to do this, then you need to make an interim application. If either party wants to stay the proceedings, they have to make an application, and the application for a stay must be made on notice to the other parties, save in exceptional circumstances. You should seek the other party's agreement to having a stay before you make any such application. The other thing you need to consider if you're going to be asking for a stay, and you can consider this with the other parties, is how long a period of time you're seeking to have the claim paused for. So you're going to need in your application to name an event or a period of time after which the claim should proceed. And this is because normally a stay of proceedings is sought pending the outcome of a particular event. So for example, there may be a related tribunal appeal, or there might be a lead case which is in the Court of Appeal, and you want the administrative court to wait until that lead case or the related appeal has been determined before deciding whether it's worth to carry on with your claim. You can also ask for a stay for a specific period of time. Again, you need to name that in the application, but the stay won't usually be more than for a few weeks or months. In certain situations, it's not really appropriate to seek a stay. For example, a stay is not the normal course if what you want to do is to enable the defendant to reconsider the decision under challenge. If the defendant agrees to reconsider the decision, the general rule is that the judicial review claim should be withdrawn. A fresh claim can then be brought if you want to challenge the reconsideration. And remember that if you don't withdraw, then you're going to need the court's permission to amend your claim form if there is a changed decision later on. I spoke about this in an earlier talk, but it may be quite a messy way of trying to keep your claim alive, to try and seek to amend it, when in fact the better course would be to withdraw your current claim and then challenge, if necessary, any reconsidered decision. One of the interim applications that people need to make quite often is to obtain what's known as relief from sanctions. Now, you'll need to seek relief from sanctions if you fail to comply with a rule of the civil procedure rules, a practice direction, or a court order, and you'll need to consider whether the rule, etc., specifies a sanction, either expressly or implicitly, for non-compliance. So for this, you do need to have a look at the rules, and a must-read is the Civil Procedure Rule, Rule 3.8 and 3.9. The person who's in default has to apply for relief from sanctions. If the defaulter doesn't, then the court may refuse to consider the defaulting party's case. This is spelt out in the Civil Procedure Rules at 3.41c. Alternatively, the court may decide to make an adverse costs order, and again the Civil Procedure Rules, Rule 44, 44.2.4a, 44.2.5c, and 44.3a.1 deal with this. So if you're seeking relief from sanctions, you need to make an interim application, and so you need to employ the interim applications procedure that we've mentioned just now. Your application will be considered possibly by the administrative court office lawyer, or the master, that's the procedural judge, or by a High Court judge. When you're seeking relief from sanctions, it's important to bear in mind the tests that the court is going to be considering. Now, you will look at the way in which the civil procedure rules are worded. And here's an idea of how the courts go about considering whether or not to grant relief from sanctions. Now, in the Administrative Court Guide, there are specific cases referred to, and it may be that you will need to go and have a look at those on the Bailey website that I mentioned in the first talk. So first of all, the court will identify and assess the seriousness and significance of the failure to comply. Now, in your application for relief from sanctions, it would be sensible for you to do the same thing. Identify and assess the seriousness and significance of the failure to comply, and you will need to consider the particular rule or order. Now, if the default is neither serious nor significant, then the court's likely to grant relief. In your application, you should be realistic about whether or not your default is serious or significant. And by the same token, if the other side is claiming relief from sanctions, you will need to consider whether they are being realistic, and you will no doubt want to point out the ways in which they're not emphasising the seriousness or significance of the breach. So having done that, the court will then go on to consider why the default occurred. And again, if there's good reason for the default, the court is likely to grant relief from sanctions. However, the guide makes clear that merely overlooking a deadline is unlikely to constitute a good reason. So you need to think about two things: the causal explanation for why the default occurred, either yours or the other side's, and also you need to consider whether the reason that you've discovered or put forward is a good reason, and you need to put your arguments relating to that. Thirdly, the court will consider and weigh all the circumstances of the case. Now, this is in order to enable it to deal with the case and the application justly, and it helps it to put the first two tests into a proper context for consideration. Particular weight is going to be given to the need for litigation to be conducted efficiently and at proportionate cost, and the need to enforce compliance with the rules, practice, directions and orders. So again, those are aspects that you will want to address when you're making your application or resisting the application by another side. One area that may concern people who are acting for themselves is that the fact that you're waiting a funding decision from the legal aid agency is not going to be a complete answer to a failure to comply. However, it is a factor that the court should take into account. So if that is your situation, you do need to point it out to the court, but you will need to consider all those tests in the round. This is a tricky area, and relief from sanctions is something that you may want to have a lawyer deal with for you, even if that's the only involvement that you have the lawyer having during your judicial review claim.